My name is Carina Kraatz, and I am an attorney with the law firm of Kitch, Drutchas, Wagner, Valitutti, and Sherbrook in downtown Detroit, Michigan. I focus my practice on commercial and construction litigation, specifically contract issues. I'm pleased to present this webinar on contract and supply chain issues today. So the first question is, what is a contract? A contract is an agreement between two or more parties creating obligations for those parties to the agreement. An enforceable contract legally requires mutual assent, offered acceptance, consideration, legal capacity, and legality. So taking those 5 different criteria and dissecting them, mutual assent is that both parties to the agreement, or however many parties to the agreement there are, they are agreeing to the mutual terms. So everyone's agreeing as to the same thing. Offered acceptance relates to, I'm offering to do something and somebody else is accepting it. Consideration. Consideration is something that legally provides value to the contract. I'm offering to supply you with 1,000 widgets, and in exchange for those 1,000 widgets, you are going to pay me $5,000. The $5,000 would be the consideration. Legal capacity. Legal capacity means somebody is legally able to enter into that contract. You have to be an adult. You have to know what you are signing. You see this sometimes with older individuals who do not know what kind of documentation is being put in front of them and do not have the capability to make their own decisions. The last one, legality. You cannot contract to do something illegal. That would be an invalid contract. What else about a contract do you need? Surprisingly, a contract does not have to be in writing. The conduct of the parties can imply a contract. So a common example from law school is the idea of a painter. You have a painter come to your house. The painter says, hey, I will paint your house. And then you say, okay, and he comes and he paints the house, and then you pay them for however much you agreed upon. So that can be what's called an oral contract. So commonly we have written contracts, but we also have the oral contract as we just discussed. With written contracts, even though it's in writing, and it seems like all of the parties would exactly understand what their obligations are, it's not always the case. Sometimes you can run into what's called a battle of the forms. Let me describe the situation for illustrative purposes. A seller of widgets has products on the market. Somebody wishes to purchase those. Purchaser sends the seller a term sheet saying, I would like 1,000 widgets. In the purchaser's term sheet, they have all of their terms and conditions for that purchase order. The seller then says, yes, I will sell you 1,000 widgets. In doing so, they send back their own invoice for 1,000 widgets, which also has terms and conditions. So you have competing terms of conditions. You have competing forms for the contract. And so what happens with that? In Michigan, we have adopted the Uniform Commercial Code. And so if you have terms that are additive, so there are additional terms, the court will just add those to the contract. But if you have different terms, so you have competing terms, then the court will knock those terms out. And certain other terms from the Article 2 of the Uniform Commercial Code will be substituted in by the court as necessary. So while this might seem like a situation that isn't common, it can be common. There are various reasons that parties will just send cross terms to each other and not actually negotiate those terms and come to a singular formal written contract. For example, time and expense. You need to get this done right away. We need the widgets as soon as possible. Another thing to be aware of in contracts is the rejection of goods versus the revocation of goods. So a rejection of goods happens before the buyer actually accepts them. You send me 100 widgets, and before I've actually accepted delivery of those widgets, I say no. I am not accepting those widgets for whatever variety of reasons. Revocation happens after I've already accepted those as the buyer. Another issue to be aware of in contracts is if your contract has any warranties. Warranties in the state of Michigan can be either express or implied. But one thing to be aware of is that if we're going to limit warranties, those have to be in writing. So when someone is trying to understand what kind of contractual obligations they have, they should review the contract. And that is especially important right now. All contracts should be reviewed. Now, to be precise, I'm not saying necessarily reviewed by an attorney. I'm saying that you, as a party to an agreement, should review that agreement so that you understand what your obligations are. You understand what you need to do in case someone is breaching. If there are terms that you don't understand, if there are provisions of the contract or sections of the contract that you don't understand, or you don't understand why they're in there legally, then that would be the time to have an attorney review it. But it is very important that you have a review of all of your contracts. So you know what your obligations, you know what your rights are, you know what any of the express terms of the contract are, you know if you have been operating outside of the terms of the contract, so that some party might argue assent, and then you know potentially what any implied terms of the contract are. If you are having issues performing your obligation to the contract, or if the other party is, then looking at the breach or the termination provisions of the contract will be helpful in order to know if you have any notice requirements, or you need to talk to the other party to try to work those issues out. A notice requirement under a contract typically provides, for example, that if somebody is breaching the contract and it's a material breach of the contract, then you can give them 30 days notice to cure. So I send you notice that you are not adequately performing the contract, you're not delivering me my widgets, then you have 30 days or whatever time specified in the contract to rectify that. And if you don't, then I have the ability to terminate. There are also certain times where damages are built into contracts. For example, liquidated damages. I hired you to construct this building. I told you I needed it done within 6 months because I was going to open the building after 6 months. You have failed to do so. We are now at month 7, and I built into the contract that for every day that you were late, I get damages for that, and that is in the contract. So every day it just compounds on one another. Another important item to be aware of if it's in your contract is what's called a force majeure clause. Because of the current situation, force majeure clauses, while typically there was something that were kind of ignored as just a legalese that was inserted into the contract, has become a very important part. So what is a force majeure clause? In a force majeure clause, a party is excused from performing certain or all of their obligations under that contract because of impossibility or impracticability. So what does that mean? Typically we're looking at acts of God, war, now people are writing in pandemics and other diseases or government ordered shutdowns, but it's something that prevents you from performing all or certain of your obligations that are out of your control. It's important to note that not all contracts have these clauses. And in a situation where a force majeure clause is not included, a court will not imply it for you. So if this is something that you are interested in having in your contracts, you need to make sure it's in there and in writing. With an oral contract, you're not going to get those types of legalese at the end of it. And when I say legalese at the end of it, I mean force majeure clause, notice provisions, warranty provisions, termination provisions. A lot of times when people are deciding on price and quantity and delivery date, they don't take into account these. So if you don't have a standard term and condition sheet, I highly recommend that you get one to further protect yourself. And so if you are running into a force majeure clause, it is very important to review it to see if it applies to your situation and why you are having an issue, or why potentially the other side of the contract is having an issue in performing their obligations. And so when I'm talking about contracts, I'm not just talking about supply contracts or contracts to build for construction projects. I'm also talking about leases. I'm talking about your rental agreements. Employment contracts. Do you have employees that are under employment contracts, or do you have independent contractors? Loan agreements and insurance policies. Right now, there are a lot of issues with whether or not insurance will cover any kind of business interruption, which is being litigated across this country right now. What do you do if you don't have a contract? While a court will not insert terms into a contract, they may imply an entire contract, as we have briefly referenced before. A court will imply a contract when one party performed and the other party did not. So common examples are when I provide a service, or I deliver some goods or a product, and you keep those, and then you don't pay me for it. I've painted your house and I didn't get paid for it. You asked me for 1,000 widgets and then didn't pay me for those 1,000 widgets. The court in those situations will imply a contract, or they'll imply a promise to do something. There are various claims that those can be called. One of them, for example, is unjust enrichment. So that means that you, as the receiver of the benefit of my service of painting your house, you received a benefit. You have to pay me for that benefit, or else you have been unjustly enriched. Now that we've talked about some contract issues, let's talk about specific supply chain issues. Unfortunately, the current state of the world and the global market, interruptions in supply chains have happened. And we all are aware of this by the inability to find toilet paper and paper towel at the grocery store. But what exactly do interruptions in supply chain cause that we may not see other than gaps in a product cycle? They can cause lost profits due to less production. I need this one specific widget to fit in my other product. I don't have my widget, I can't build my product to sell. There are also potential contractual damages due to decreased or delayed production. I, as a middleman, so to speak, in the production chain, I'm waiting on this widget from party A. As party B, I'm waiting on this widget to build what I need to do for my product so I can sell it to party C. I may be in risk of breaching my contract with party C because I'm waiting on party A. How does that affect me contractually? What kind of terms do I have in my agreements with both party A and party C that I can use to help protect myself? There are also sourcing product issues. If I can't get my widget from party A, do I go to party D to try to get my widget? Party D is charging triple. I can't afford that, I'm gonna lose money. You potentially run into issues of economic duress or coercion, where I have to buy this widget, but it's so much more, but if I don't, I'm gonna breach my contract with party C. Supply chain issues also cause potential loss of customers. If I don't provide my product to party C, I might lose them as a customer. If I can't perform my services to party C because I'm waiting on something from party A, then I might lose party C as a customer, not just right now, but in the future. There are also other legal issues such as breach of contract or unjust enrichment issues, negligence that one will have to be aware of as well. So how do you address these issues? There's the alternative sourcing of goods, as briefly referenced. If I am waiting on a widget from party A, and party A doesn't have it, I'll go to party D. Hopefully party D isn't charging triple what party A is. You can also look at risk management. Looking at my supply chain, do I have multiple options for my widgets, or am I relying on just one? How much of a risk is that for me to not have multiple sources for my products or my components that go into a product? Doing a sort of risk assessment requires a periodic review and assessment of your supply chain. This isn't something that should be only done after the fact, but in order to really get the full benefit out of conducting a risk assessment, you want to do it periodically as the landscape is changing, which it is quite rapidly right now, but it is important to do a periodic assessment so that if you see a potential issue, you can broach it beforehand. You can have a plan of action beforehand. Another way to mitigate supply chain issues is for a redesign of products for more common components. For example, party A is giving me a very unique widget that fits precisely into my product just so. Maybe I redesign my product so that instead of being reliant on party A for my specialized widget, it's, oh, I can fit any old widget in there. Another option to deal with supply chain issues is business reconfiguration, going top to bottom in production versus just being on a horizontal level and seeking products from everyone else or seeking components from everyone else. Another thing to be aware of when dealing with supply chain issues is to make sure that all of your contracts are actually in writing. The state of Michigan, as I previously mentioned, has adopted the Uniform Commercial Code. In Michigan, we have what's called the statute of frauds. And for the sale of goods, that means that all contracts for the sale of goods priced above $1,000 are enforceable only if sufficient writing signed by the party against whom enforcement is sought is documented. So what that means is if you are trying to enforce a contract against me for $2,000 worth of widgets, I have to have had to sign that agreement. If not, it doesn't meet the requirements of the statute of frauds under the UCC and can be voided. Now, that being said, there are also two types of contracts which generally meet the requirements of the Michigan statute of frauds. Now, it's important because, as we referenced previously, sometimes when parties are negotiating contracts, they can be in a little bit of a rush. They can be in a hurry. I need these components now. I don't have time to negotiate terms and conditions. That's why I'm sending forms back and forth, and we have a battle of the forms. So we're looking at two different types of contract forms. First is a fixed quantity contract. I am buying exactly 1,000 widgets from you. The second is an exclusive agreement. In that type of contract, that means you are going to supply me all of the widgets I need. 100% of my need comes from you. Where you run into risks are sometimes when people are having the battle of the forms, or there's haste, or people want flexibility, you run into blanket purchase orders. You might have issues with enforcement due to some of the competing court cases in the state of Michigan. So what are some of the key takeaways? All contracts should be reviewed. You need to know what your obligations are to the other parties in those agreements. You need to know what type of notice provisions that you have. What do you do if you are in danger of not performing or someone else is? Additionally, being proactive allows for the most options. If you know that you are in danger of not performing or somebody else is, and you're providing those notice provisions, you might have the ability to do a workaround. Okay, you're not gonna provide me 1,000 widgets this week as you contractually obligated to, but you can provide me 2,500 next week. That works for me. You know, different outside of litigation options. And when you're trying to work with people, you can potentially avoid lawsuits if you do have some sort of agreed upon plan. I want to thank you for your time today. Again, my name is Carina Kraatz. I am a principal with the law firm of Kitch, Drutchas, Wagner, and Valitutti in Sherbrook. I'm happy to answer any questions. Thank you.